All rise. Department 12 is back in session with Honorable Judge Israel presiding.
Please be seated.
Take your seats, come to order.
Good afternoon.
Page 4, Blandino.
Blandino. Mr. Bateman here with the defendant. This is the calendar call. You ready to go?
Judge, I don't think that I am. There is a, the defendant has a motion to dismiss me as counsel that has not been heard. I indicated to Mr. Dickerson that I would be announcing not ready, but really nothing's changed since I had a motion to withdraw that was heard a little over a month ago. That he has not been cooperative with me in getting prepared. He still is insistent on trying this or representing himself and not having me do that. And so, in that part of that and part of my motion, Judge, was that he was insisting on testifying or putting on testimony, in other words, that would have me violate the rules of professional conduct. Since then, Judge Levitt said that he would be allowed to testify in narrative form. So, I have not really been able to go over, really prep with Mr. Blandino. So, with those motion to dismiss me as counsel, I am not ready. I don't feel that I'm ready to proceed to trial. And those are representations.
This is the 8th trial setting. Did Judge Levitt, it says Judge Levitt revoked his pro per status in December.
Correct.
And denied Mr. Bateman's motion to withdraw in January.
That's correct.
So,
representation, yes.
So if he is choosing voluntarily not to cooperate, that's his choice.
And I just want to, but I do want a clear record made of that.
I think you made your record just now.
Well, that's.
I understand, but if an individual chooses not to speak ever, then let's say on a case, and chooses, then what is it anybody can do? I mean, he's going to go to trial. Mr. Blandino, you want to say something? Are you sure you want to do that?
I have to, Judge.
Go ahead.
The representation Ben's making is not quite accurate. I call every day. I have tremendous amount of materials, exculpatory information. We met for about an hour and a half yesterday, and Ben had his family day and everything with President's Day and everything. I understand that, so we want to get back at family, so we met for only about an hour and a half. I could have met for 6 hours. I've got tremendous amounts of exculpatory evidence and stuff that he just doesn't think that is necessary. I have absolutely no trust under Young versus State, which I put in my notice and demand, which the court can consider as a motion to dismiss counsel. Let me go back to representing myself, or give me a chance with another counsel. I have non-frivolous pre-trial motions to dismiss and everything to present that I couldn't present as myself when I was representing myself, because I'm presenting it to a judge that should and will be disqualified at some point if I go to federal court or this thing isn't disposed of otherwise, because there's no way that any judge in the Judicial District Court should be hearing this case. And so there's discovery issues I went over. We went over the hard drive, the mirror image copy drive that Mr. Dickerson gave us. And he said that I told him we couldn't find one of the initiating documents. This is extremely exculpatory because I'm in charge with extortion, category B. So, and this was at the behest of the complaining witness victim, alleged victim, he said, well, send me something that will resolve the matter and send it an email. So I went on the internet and I pulled up a settlement agreement that is authorized and accepted in Nevada and did a cut, copy, and paste. And nowhere in that hard drive that we could find a copy of it is that original document, because I didn't go look up an extortion document.
Well,
I
we're
looked
not
at it.
trying your case
No, I
here
understand that. What
today,
I'm saying is,
etc.
under
You're
the
going to
auspices-
trial on the 28th. You need to go to the central trial readiness tomorrow, and that's at 2 o'clock, in Judge Steve Jones, who will, whether it's case goes in front of Judge Blatt or another judge, probably it will be, I believe she's in trial, which is why I'm doing it. It'll be sent to another judge. But this is the 8th trial setting. The case is over 2 years old. I didn't ask, but Mr. Dickerson, are you ready to go?
Proceed forward that we'll have to address with the court, but expect the trial to be able to conclude by Thursday or Friday. At least our case in chief will have between 5 and 6 witnesses probably.
Thursday and Friday of what, if I may ask for clarification?
Well, the trial is scheduled to start on the 28th, which I assume, let me check, is a Monday. And so he's saying his case, the witnesses he'll be putting on, will be done by Thursday. But you can discuss all of that with that Mr. Bateman, you have to do what you have to do. And as I said, the 8th trial setting, so this case needs to go. And
But if I may, Judge, respectfully, Young versus State is clear. If I've lost all trust in Ben Bateman,
then take it to you have
I
your
have no
rights to
counsel
appeal.
whatsoever. It's the
Yes, you
same
have
as
your
no
rights
counsel.
to appeal. Judge Levitt has already ruled on those. There's no motion in front of me, so you'll be going to the central trial tomorrow.
Your Honor, may we request a transcript of this hearing?
Sure.
Thank you.
All right, that's it.
Thanks, Judge. Thanks for letting me speak.
Next we call page 10.